At the conclusion of this lecture, you will be familiar with what is meant by law and understand how legislation is formed. Before examining the fundamentals of the English legal system, it is necessary to understand the general division of law. Whether a country is common law or civil law in nature, it maintains a division between public law and private law. Public law refers to the relationship of the state with individual citizens, and as a result, it includes constitutional, environmental, administrative, and criminal law. In essence, where the good of society as a whole is affected, the state will intervene under public law. Private law relates to issues between one or more individuals or organizations that are affected by the issues directly. Here, the state will not intervene unless the public good is threatened. Private law includes contract, tort, and land law. There are 5 principal sources of UK law: legislation, common law, European Union law, custom, the European Convention of Human Rights. The sources of law are not limited to the above. Other sources of law include international law and regulatory body rules and regulations. For the purpose of the ACCA exam, it is sufficient to be familiar with the above 5 sources. Thus, there is no single series of documents that contain the definitive law of the UK. We will now examine the 5 sources of law in the English legal system. In terms of understanding legislation, it is important to remember 3 points, and they are: legislation is law that is created by the legislature. Legislation is produced through the parliamentary system. The parliamentary system consists of 3 elements: the House of Commons, the House of Lords, and the Queen. The House of Commons is composed of 650 members of Parliament. These 650 members of Parliament represent the whole of the United Kingdom, where each member of Parliament represents a defined geographic constituency. In order to become a member of Parliament, one needs to be elected in his or her local constituency. Each elector has 1 vote, and the candidate with the highest number of votes is elected as Member of Parliament for that constituency. The House of Lords consists of around 800 peers. Around 600 members are formally appointed by the Queen, on the recommendation of the Prime Minister. The other members of the House of Lords are people who have inherited aristocratic titles such as Lord or Lady, and senior bishops of the Church of England. Members of the House of Lords are not limited to their function as lords within the House, and can take up positions as government ministers. Only the House of Commons and the House of Lords can introduce a bill to be enacted as an act by the Parliament as a whole. Historically, the House of Lords was a very powerful entity in the English legal system, where the House of Lords could prevent bills from becoming law, even where the House of Commons voted in favour of them. This power to veto a bill was limited by the Parliament Acts of 1911 and 1949. As a result of these acts, it is now possible for the House of Lords to delay a bill for up to 1 year. Apart from money bills, which are bills connected with the budget, these can be enacted without the approval of the House of Lords after a delay of 1 month, after which the government can reintroduce the bill, and if it passes in the House of Commons for a second time, it becomes law. The reasoning behind this change is that the prevailing will of the House of Commons is due to members of Parliament being the democratically elected representatives of the citizens. The power is used very rarely. An example of where it was used can be seen in the passing of the Hunting Act in 2004. As with most of the powers that are vested in the Queen, the monarch has an important formal and ceremonial relationship with the Parliament. Only the Queen can summon the Parliament and discontinue the Parliament without dissolving it, or simply dissolve it. This can be done upon the request of the Prime Minister, who wishes to dissolve the Parliament and call a general election. Legislation is perhaps the most important source of law today within England for 2 reasons. Firstly, in terms of quantity, the Parliament produces far more legal rules than any other source. Secondly, and perhaps even more importantly, the doctrine of parliamentary sovereignty within the United Kingdom means that the Parliament is the ultimate source of law and, at least in theory, it can make whatever laws it wishes. It is an effect of this doctrine that the courts cannot challenge either the authority of the Parliament or the laws it makes in the exercise of that authority. Within countries with written constitutions, there is usually a limitation placed on the power of the legislature to make law, in that it cannot make laws which are contrary to or in conflict with the fundamental provisions of the Constitution. In the United Kingdom, due to the doctrine of parliamentary sovereignty, legislation is superior to the common law, and the courts cannot strike down primary legislation. Before joining the EU, parliamentary sovereignty meant that the law made by the UK Parliament could not be challenged. This proved to be a key obstacle. The UK successfully joined the EU in 1973, but before it could do so, it had to pass the European Communities Act 1972. The European Communities Act effectively ended parliamentary sovereignty, so that EU law now takes precedence over national law. The 1972 Act was appealed to the courts in the case of Orr versus Secretary of State for Transport ex parte factortem, where the courts held that where there is conflict between a UK statute and the Treaty of Rome, the Treaty of Rome takes precedence. Before any legislative proposal, known at that stage as a bill, can become an Act of Parliament, it must proceed through and be approved by both Houses of Parliament and must receive the royal assent. The Companies Act of 2006 was an example of a consolidation act. Codifying legislation, on the other hand, seeks not just to bring existing statutory provisions under one act, but also looks to give statutory expression to common law rules. The Partnership Act of 1890 is a good example of this. Many people do not realise the huge amount of secondary legislation made under the Authority Act of a Parliament. The Act of Parliament gives authority to a person, for example a Secretary of State, or other body to make the detail of the law on the Parliament's behalf. For this reason, secondary legislation is also known as delegated legislation. It takes a number of forms, but the most used type of delegated legislation takes the form of regulations or orders known as statutory instruments. Other advantages include: it allows Parliament time to concentrate on other more pressing legislation, which oftentimes will require most of the Parliament's attention and resources. It is faster if legislation is delegated, as getting a piece of legislation through Parliament is a very slow process. Delegated legislation allows fast amendments to the law to be made in order to keep pace with changing circumstances. It allows consultation with experts on technical topics and keeps the detail of the law in a simple format that can be easily understood by anyone. Delegated legislation has also been criticized for being undemocratic because it can be made by uninflected individuals, often without a formal consultation process, and with very little publicity. Additionally, delegated legislation gives a lot of power to civil servants who may not necessarily be qualified to create the delegated legislation. In summary, there are 5 main sources of law in the English legal system: common law, legislation EU law, custom, and the European Convention of Human Rights. Delegated legislation is another name given to secondary legislation. Legislation passed by the Parliament is referred to as primary legislation.